We now take up the second case on today's docket, Bright versus the State of Florida. Counsel.
My police court, my entire wishes were upheld. Let me know if my speech needs to be repeated. Thank you. I would like to devote my argument to issues 3 and 4. But do you have any questions on issue 1 or 2? May I proceed to issue 3?
Yes.
Thank you. We believe the state abused its discretion by failing to assign any weight to the negatives presented. Primarily, the trial court in its order did state the facts that were in this court's opinion. The 2 prior opinions from the court, mainly the direct appeal. I realize those facts were not before this penalty jury, but they were known to the trial judge, yet he refused to consider them, and he went with the prosecution theory that the victims were slain or hit in their sleep when they were true police statement by my client of the fight began when the victims were waving guns in his own home. And I understand we can't argue self-defense. That's not my point. My point is to put the right perspectives of the case. And with that, I argue that there was insufficient evidence of hack. So, the trial court in its order said that my client attacked sleeping victims. However, the ME testimony of defensive wounds did show it is consistent with my client's statements of struggle over a gun. There were 2 bullets found, one in the other room and one behind the couch. They verified there was a struggle over the gun, again consistent with my client's statements. The trial judge also relied on the image testimony on direct that King, the victim, was conscious during the attack. However, on cross-examination, she stepped back from that and said actually one blow could have been fatal and King could have been not unconscious. There's no way to tell how long King was conscious during that attack. Also, she testified that there was no evidence that King's wounds swelled or had time to swell. Again, that shows that King probably did not have prolonged suffering. I will also ask the court to look at the testimony of his wife and the lawyer who saw my client right after the attacks and described his demeanor as shocked, emotional. This was not a move done just to put pain. It was not done to the enjoyment of suffering as required by a finding for hack. Any question? I acknowledge. Let me also say that the error is not harmless because the other aggravatives of prior violent felony was armed robbery, where my client did not injure anyone. He simply displayed a knife after he received the cash from the cashier. He left, no injury. And then the aggravator was the second murder done in the same episode in the instant case. So the finding of hack is not harmless. I also recognize that error for hack on this issue does not affect the other death sentence. And the fourth issue. If you look at this court decision in Korea, it says yes, that the court has discretion to deny a mitigate even if there's competent evidence. However, there must be some unique fact of a case to warrant that disregard. I argue before you today there is no such unique characteristic to warrant the disregard of the overwhelming evidence that supports these mitigatives. And number one, they are that he acted under extreme emotional and mental disturbance. He had a horrible childhood that you have all read about. And there was reason that he had never committed this type about the crime. And that this particular crime took place in his home. He had nowhere to go. He had been to a place many times about these two people in his home. And he got no protection. And that these two people that were in his home, they were the ones who had the guns, not my client. And rather than seeing it, he tried to leave. He tripped and fell. That, at that moment, as Dr. Gold testified, that is a nexus because a piece of childhood did the incident that happened in this case. Because in both settings, he was in his own home, being threatened, with nowhere to go. And then that is what triggered the PTSD. And when he fought back, he had both the victims. The only weapon he could reach for was a hammer. And he acted as in self-defense, in his own mind, in self-defense. That was good to also lack of capacity to understand the criminality of his behavior. I will recognize that he buried the guns in the backyard. And that was what the court relied on to deny that murder. Yet, if you don't want your identity from a crime, would you like to bury the weapons in the backyard and leave the victim's vehicle parked in your driveway? Go to his wife and agree to get a lawyer? As Dr. Gold testified, those acts of burying a weapon in the backyard was not inconsistent with PTSD because he was still acting in a disassociated state, and they were bringing back to Cody. Well, Cody, the state presented so many witnesses that showed Cody never committed a crime. The trial court found, based on that witness testimony, that Cody had the capacity to understand his action on criminal action. This court said, 1 minute, those lay witnesses had never seen Cody act when he is rejected by other men's partner, which was the truth. And so this court defined that the trial court Cody erred by not assigning weight to that mitigator. I will move on to the abuse of did catch all naked. And Dr. Gold testified at length to the abuse. But the trial court found that some of the evidence substantiated. You had the sister testify to the same abuse. You had the childhood friend testify that he witnessed some of that abuse. The trial court also said ahead the sister turned out alright to it didn't matter. But the sister also testified that my client got the brunt of a physical, sexual, and emotional abuse from not only his father, but his brother. He was scored 10 inches, 10. And Dr. Gold testified he had never seen anybody with 10 fractures of inches before.
Counsel, I just wanted to note that you are now consuming your rebuttal time. You have about 3.5 minutes left.
Yeah.
So if you may continue, but I just wanted to.
Thank you. May it please the court. My name is Lisa Hopkins. I represent the state in this matter. We are here after the resentencing of Raymond Bright for the deaths of Derrick King and Randall Brown. On February 18th, 2008, the defendant took a hammer and bludgeoned both Derrick King and Randall Brown to death. Dr. Rao, the medical examiner, testified that Derrick King suffered over 38 injuries to his head and 20 to his extremities. He had injuries consistent with defensive wounds, and also testified that Mr. Brown had over 20 injuries to his head and also to his extremities. Now, counsel addressed issues 3 and 4, so if I could start with those. Regarding the AJC aggravator, in this case, there was competent substantial evidence to support providing the AJC aggravator to the jury as part of the instructions. Defense counsel at trial did not object to the AJC being given. Therefore, this would be subject to fundamental error. In this case, Dr. Rao testified to the defensive wounds on both victims, as well as the fact that there was no gunshot residue on the hands of either victim, which did dispute the argument that the victims had started this altercation. Under this court's precedence of rolling, consciousness may only be for a few seconds, and AJC will still be a valid aggravator to be found by the jury. In this case, the jury did hear the evidence of the brutal murders and found unanimously that the AJC aggravator applied to Derrick King. Dr. Rao also testified that there was bruising on the victims, which does support supports the evidence that they were alive at the time of their death, at the time of this attack. Now, in addressing issue 4, now the court clearly considered the mitigation. In its sentencing order, it went through the factors, it went through the evidence. Dr. Kropp, who had originally interviewed the defendant within a few months after the murders, found Mr. Bright to be intelligent and able to communicate, and did not find him to be under emotional distress at that time. But didn't Dr. Gold find that Mr. Bright was experiencing PTSD? Isn't there competent substantial evidence to establish that? Yes, the court did consider it. The court, however, found that because Mr. Bright had served in the Marines for over 9 years after once he became an adult, and he was able to be a productive member of society during his time in the Marines, he received several promotions, commendations, and found that there was a sufficient break between the childhood abuse and this attack that showed that Mr. Bright was able to conform his conduct to the norms of society and be a law-abiding citizen. So the court did consider it and ultimately rejected it.
I'm sorry for interrupting you, but I mean, given the evidence that was put forward that was suggesting that there was a specific nexus between the circumstances of these men being in his house and how that, caused him to be triggered in some way. I mean, is the fact that he did have a productive life, after the military service, I mean, is that enough to kind of overcome the evidence of that nexus that was there?
I believe it is. In this case, 9 years in the Marines, including an incident where he received a commendation for noticing a dangerous condition on a plane and ultimately potentially saved someone's life, preventing that plane from crashing. Mr. Bright, at the time of this murder, was 54 years old. The victims were 16 and 20 years old. This childhood abuse occurred almost 30 years, and there was a sufficient break. And I think the court was well within its discretion to consider that and look at his actions as a whole, his actions including what he did after the murders, in which he buried the weapon, he covered the bodies, he went over to his ex-wife's house after he was arrested. The ex-wife did burn his clothes. He buried the gloves, which show a intent to hide what he did.
Well, but wasn't there evidence in the record to show that Mr. Bright had alcohol problems and that's why he was discharged from the Marines, and that alcohol problem stemmed from the PTSD that he had from childhood?
Well, Dr. Kropp ultimately did not find there was PTSD when he initially interviewed him within the few months after, but
should we look at Dr. Kropp's testimony, because wasn't that part of one of the reasons that the case was overturned before, for the deficiency of counsel during that time?
there was additional evidence. And again, there were 2 doctors that did testify at the new penalty phase that did go more in detail into the childhood abuse. Dr. Kropp had to rely on what information he was provided when he did his...
Right, so he wasn't provided full, he didn't have a full history to look at, like
Correct,
Dr.
but he did
Gold.
have that full history at the resentencing.
Oh, so let me ask you, let's assume that we believe it's error. Is it harmless error?
Yes.
Why is it harmless?
In this case, the jury was able to hear all of that mitigation. They were able to hear about the childhood abuse that Mr. Bright had experienced as a child, and they rejected that. The jury, in rejecting the mitigation, found 1 to 11 that neither statutory mitigation was found, and also rejected non-statutory mitigation.
What's our standard of review for those mitigators that the trial court did not find? So is it if there's competent substantial evidence supporting that finding?
It would be an abuse of discretion.
So if there's evidence in the record to support a non-finding, that could not be an abuse of discretion,
Well, the court
correct?
found that they existed, but then did not give them weight.
Well, I'm talking
So-
about the statutory mitigators, specifically regarding the PTSD and some of the other things and its effect on what happened at that time.
Well, the statutory mitigation would be the extreme emotional distress, which was rejected given his actions after the murders, which this court has held in similar cases that is perfectly appropriate to reject that mitigation.
But if there's, I guess my question is, if there's evidence in the record to support that finding, then that's not an abuse of discretion. You would agree with that?
Correct.
Okay. Dr. Kropp's deposition from 2008 was in the record, was it not?
Yes.
All right. Was there any objection to it being considered by the court So I understand it came in without objection.
I believe it came in without objection.
Okay, and Dr. Kropp specifically found that he, after testing, after interviewing, there was no indication of PTSD at all, correct?
Correct.
And indeed, Dr. Kropp specifically found, or specifically when talking to the defendant, found that there was no childhood abuse at all that would have caused PTSD, correct?
That's correct.
Can't the trial court rely on that exact information, however weight we might give it in hindsight,
Right.
in making the findings of no extreme emotional distress?
That's correct. The court can rely on that. That is competent substantial evidence.
Thank you.
If there are any other questions on this issue, I'd like to move on. I just want to address proportionality in this case, given that, which is always considered in these death cases. I'd like to cite to Singleton v. State, in which this court found that the sentence was proportionate where a victim was stabbed 7 times. The defendant claimed the stabbing occurred during an altercation.
Didn't we already find it proportional in the first appeal?
Yes, in that case, the HAC aggravator was applied to both victims as well as the prior violent felony. In this case, the HAC was applied to only one victim.
But the conduct was the same, the facts were the same.
But the conduct was the same, so it would be the state's position that this sentence is proportional, even with the additional mitigation that was provided. This is still an appropriate sentence for the facts of this case. And seeing no other questions, I would be relying on my brief and ask that this court affirm the new death sentence. Thank you.
I would like to address Ms. Dr. Kropp's testimony as Justice Lagoa pointed out. Dr. Kropp was not provide all the evidence. In fact, that was the reason why my client got a penalty filed because he testified at this trial that he asked for the evidence from a trial order and wasn't given it. And Justice Randall pointed out there was a direct nexus between what happened in my client's childhood and what happened that night. The fact that my client did not do any crime as an adult has been very honest because this set of circumstances of having somebody in his own home threatening him. And after he had already gone to the police to complain and no action, there are specific facts that had not been present before, not in the Marines, not in so the passage of time is not relevant to the finding of PTSD. Or to the competent evidence of emotional and mental disturbance. If there are no questions, I'll ask the court to reverse the death penalty for my client, or in the alternative, to order in the penalty phase. Thank you.
Thank you.